in many respects, propped up by this philosophy of naturalism. That's what holds it up. Naturalism rules out the evidence of design, which actually is the counter-argument to evolution's core claim of no design. So when that counter-argument is ruled out in a historical science, the only competitor is disallowed. That essentially winds up being a violation of the scientific method. It is this infrastructure which is not disclosed, which is actually used, as we've heard testify today. Now what happens is that none of this is really effectively described in the textbook. And so the textbook is almost like a tablecloth has been put over this pedestal, and the only thing the students see is we use the scientific method. We develop all of our explanations using empirical science, and so the students are led to believe that this is really supported by empiricism rather than naturalism. What we propose is that instead of using naturalism or religion, we use the scientific method. The minority report does not require that this evidence be shown, but at least it requires students to understand criticisms of that. Now I'd like to talk briefly about the legal issues. How much time do I have left? Okay. I think that what Dr. Harris said we proposed to do in these hearings was to show that there is a genuine scientific controversy about origins. And I don't see how anybody can deny that, given the testimony that you've heard during the past 3 days. There is a clear and undeniable scientific controversy about the origin of life. We heard one witness say, I just don't see that it's possible that a physical chemist, that it's even possible that you could ever get life started in a random self-assembly process. Of course, there may be explanations. It's an historical science, and it may be, 5 years from now, we will actually discover that. And then that evidence goes in the scales, and the scales are constantly moving up and down. But we have shown that there is a scientific controversy about origins. Secondly, we have shown that the controversy unavoidably impacts religion. The side of the controversy that supports the idea that man is the product of an unguided evolutionary process, that side, which is evolutionary biology, supports but does not require one kind of religious belief and conflicts with theistic religious beliefs. So, we saw an example of that in spades in the Humanist Manifesto. The secular humanism was decided in the Smith case, in I believe 1987. It was a fascinating case. It involved books in a school that were charged to be promoting secular humanism. By the way, none of the books involved science books or biology textbooks. And so the court had to make a decision, is secular humanism a religion? Because if it wasn't, then there wouldn't be an issue regarding the books. And the court took an enormous amount of testimony and concluded ultimately that secular humanism is a religion. It found that it was a religion because the tenets of secular humanism is that there is no reason to believe in the existence of a creator Well, why is there no reason to believe in the existence of a creator? It's because an evolution unguided process is perfectly capable of producing life as we see it, and so there's no reason for us to even imagine one. Given the lack of any reason to believe in a creator, we can ignore traditional religion, and we use human reason to decide our ethics and morals. And the very last portion of the description of secular humanism that the court decided on explained that the entire basis of secular humanism is grounded on the principles of modern naturalism and physical science. So you see that naturalism is an important ingredient in the philosophy and the religion of secular humanism. Of course, there are others: atheism, agnosticism, and scientism. So one side of this origins controversy supports those types of non-theistic beliefs. The evidence of design, which is essentially the opposite of evolution's core claim of no design, that idea and the evidence that supports it does not require, so long as it's kept theoretical, does not require, but certainly supports theistic beliefs. And so you have, and what we've shown is that there is a controversy over those issues. Now, what the Minority Report seeks to do with respect to that religious controversy is to use what science calls for at its core, and which is particularly necessary in origin science and historical science, is a good measure of scientific objectivity. And when you are objective, you allow students to show evidence that supports and that does not support a particular theory. It is important that we're talking about objectivity at the institutional level. Every scientist is going to have his own bias. It's just like when we go to a courtroom, we're looking for an unbiased adjudicator of the particular result. So when we go into a science classroom, it's essentially the job of the public school and the job of the teacher to put behind themselves, to put aside their own personal, philosophical, religious biases, and simply do good science. Let the scientific evidence dictate what is shown to the students on both sides of that issue. And that's precisely what the Minority Report does. That achieves not only the best science, but the best science education. What is so fascinating about that approach is that when you do an objective approach, what you do is you take the bias out. You take a bias out. Whenever you have a bias in a religious discussion, you're not going to have neutrality. And that's essentially what the Constitution calls for, is when the state decides to embark upon, enter an arena which touches the religious sphere. When the state chooses to do that, you trigger Establishment Clause responsibilities. If we were talking about gravity and there was a controversy over it, or if we were talking about string theory and there was a controversy over it, that wouldn't implicate Establishment Clause. But when we're talking about origins, where do we come from, then you've gotten into a religious discussion. And so the question is, how are you going to discuss that? How are you going to conduct that discussion consistent with your Establishment Clause obligations? I believe there are two cases which are particularly important in essentially control the outcome, but they're very, very misunderstood. The first case I've mentioned is Epperson v. Arkansas, and that was a Supreme Court case that was decided in the late 60s and it related to the state of Arkansas that adopted a statute that would essentially suppress one theory of origins. So, what is the origin of life? You have evolution over here, and then you have theory that criticizes that. You have scientific criticisms, and then you have the idea of design. Well, what happened in Epperson was the state of Arkansas said that when you enter into a classroom and you're going to talk about origins, when you go in there, you have to take the evidence in this hand, this is evolution hand, and put it behind your back. And the court said, no, you can't do that. You're in a religious sphere. You're favoring one kind of view over another. The court said, essentially, if you were going to discuss origins, the only neutral way you could do it is to show both or put both hands behind your back. And practically it doesn't work to put both hands behind your back. So I think Epperson is essentially our case. In our case, instead of the state doing this, the state is doing that when it embraces methodological naturalism. And that is Epperson v. Arkansas in spades. Now, subsequent case of Edwards v. Aguillard was a bit different situation, but it wasn't. But the mechanism in the Louisiana statute was to say you can teach this evolution, but only if you bring into the classroom creation science, which is science designed to validate the literal interpretation of the book of Genesis. And the court said, this idea essentially ties into a religious text. This is religious. If you have to do this, you have to do this, then you are actually infringing upon the academic freedom of teachers to teach this. And that, in fact, has a suppressing effect, and it's being done for religious purposes, and so that's not appropriate. The most interesting quote in the Edwards case is a description of what the court said should have happened. And I don't have my reference here, but essentially what the court said, that if the Louisiana legislature had really wanted to do effective science education, to maximize the effectiveness of science education, it would have simply permitted teachers to teach all theories relating to the origins of humankind. It essentially was, teach both sides. That was so in my mind, Edwards is a similar instance of the state taking some action that would actually suppress the mix of information that would be given to students about this concept, and the mix of scientific data and information. And so I think both Epperson and Edwards are consistent with the idea that to teach origin science constitutionally, you must do it comprehensively, limited to scientific explanations, scientific data. And I think you heard all of the witnesses testify today that that is precisely what the Minority Report does. It limits the discussion to scientific discussion, but within that limit, it opens up the discussion immensely. And when you open up that discussion and you allow the evidence to come in, you remove fear from the classroom. You remove the tension from the classroom. Students can raise their hand and ask questions because they're being shown both sides. They're being encouraged to critically analyze this issue. You won't have Jill Gonzalez coming in here in a massive worry about the impact of her testimony on her career. You won't have, I get calls from teachers all the time. I had a teacher call. She said, I showed Unlocking the Mystery of Life in my science education class, and the next day the department of the biology in our high school went to the library and said, remove that video from the library, and he'd never even seen it. And I submit that anybody who has seen that video would acknowledge that it is purely scientific, purely legitimate. There is absolutely no reason for that to happen. But what happens is that the other science teachers in that classroom see what happens to Miss Gonzalez, and you wind up freezing the discussion in its entirety. And that winds up, and essentially it winds up with teachers not really teaching evolution effectively. Because they're afraid to teach it. If they teach it per the textbook, the students and the parents are going to get upset. If they teach criticisms, their peers are going to lean on them, and they will be guilty of, quote, doing something that weakens evolutionary theory. A breach of the rules that just can't happen. Rodney LeVake, science teacher in Minnesota, he has a master's in biology, and he was reassigned from his biology class because all he wanted to do was teach evolution honestly. And there is a real problem when teachers can't be honest in a biology classroom. So, I think the Establishment Clause is, I want to show, see how much time do I have left? Okay, I want to show the NAGB policy. Okay. When No Child Left Behind was enacted, there were added, when No Child Left Behind was enacted, in addition to the report of the conferees, which contained the Centaurum language that Dr. Abrams has been reading and that is contained in the minority report, the provisions of No Child Left Behind contain a clause in many of its provisions that require that services and materials delivered by educational agencies be secular, neutral, and non-ideological. And you see this language here. The provision, one of the provisions provides that if a child is left behind under the matrix of the guidelines by a school, the parents of the child can then select a outside provider from the public school system to provide supplemental services. Now, for the provider to meet the requirements necessary for the delivery of these outside services, the provider must certify that the services it will deliver are secular, neutral, and non-ideological. And the second requirement is that they be consistent with state standards, state educational standards. Now, the implicit effect of that two-pronged requirement is to require that the state standards themselves be secular, neutral, and non-ideological. And that only makes sense because the phrase secular, neutral, and non-ideologically essentially reflect much of the jurisprudence of the Supreme Court on the issue of public education. Well, the provision was also imposed upon the National Assessment Governing Board, which prepares the nation's report card test. So the NAGB had to define that phrase, secular, neutral, and non-ideological. The definition of secular is interesting because it says questions will not contain language that advocates or opposes any particular religious views or beliefs. not advocates or propose any particular religious views or beliefs. Well, religious views or beliefs consist of theistic and non-theistic. So what does methodological naturalism do? Which belief system does it favor? Well, we've heard a lot of testimony today. It favors non-theistic beliefs. Is it appropriate? Is it secular for the state to adopt and embrace methodological naturalism and suppress evidence that is relevant? Whether it's religious or not, it is clearly relevant. It is scientifically gathered. It's not drawn from a religious text. It's clearly relevant. What is how can that be secular? In fact, the stated reason for methodological naturalism is to keep the supernatural out. That is a reason that is related directly to God. So in order to keep God out of the question, we are going to suppress evidence that might lead one to that idea. I submit that is not a secular purpose. That is a purpose relating to religion, and so it runs afoul of that particular requirement. Next, look at the definition of neutral and non-ideological. Items will not advocate for a particular political party or a single perspective on a controversial issue. And that's what methodological naturalism does, is that it ensures that only one side of the scientific controversy we've presented to you will be shown to the students. Thank you for listening to my testimony, and we will provide a detailed legal brief in our final submission.
Not having your legal brief makes it difficult for me to question you about your legal assertions. However, you have raised a couple of issues that I think are important to discuss. You mentioned the Epperson case, and thinking that you might attempt to rely on such authority, I did bring a copy of that case that I will include in the record. Epperson et al. Versus Arkansas, number 7, is a Supreme Court of the United States case cited at 393 U.S. 97, 89 Supreme Court 266. It was argued on October the 16th, 1968, and decided November the 12th, 1968. That case stands for the proposition that a statute that makes it unlawful for a teacher in any state-supported school or university to teach or use a textbook that teaches that mankind ascended or descended from a lower order of animals is unconstitutional. Which is to say, is it not, Mr. Calvert, that case, in fact, stood for the proposition that the statute, which was a product, and I'm quoting now on page 2 of the opinion, the statute was a product of the upsurge of fundamentalist religious fervor of the 20s. The Arkansas statute was an adaptation of the famous Tennessee monkey law, which that state adopted in 1925. Now, you would agree with me, would you not, sir, that as far as the Establishment Clause of the United States Constitution, it is important that in public schools, teaching should be secular in the science curriculum, correct?
I agree with that.
And the only argument that you have with which to impeach mainstream scientists in this country and the teaching of evolution as it occurs every day in Kansas and across this country is your view that that science, evolution, is biased by methodological materialism, correct?
Methodological naturalism.
Methodological naturalism.
Well, or scientific materialism. I think that comes close to articulating what I said. I think evolution by itself, without the bias and the prop, is a perfectly legitimate scientific theory. It's when you combine it with methodological naturalism in origin science that it has the effect of promoting a naturalistic belief system.
And in order for your argument to hold water, we would have to assume that the majority of scientists in this country, including every major scientific organization, is biased in the manner that you suggest.
No, I think that doesn't follow. I think that there are a huge number of scientists that themselves don't even recognize the existence of the bias. And I think that there are a number, even those that do, or that maybe don't, that are in dissent of the science elite, as I might say. I mean, I run into scientists all the time, and they say, yeah, I know that's what they say, but I can't subscribe to that. But they suffer significant professional retribution if they happen to be in the academic community. It's a tenet that they have to abide by, or they wind up like Nancy Bryson. We just saw an example of it.
Would you agree, sir, that with respect to the teaching of theories of origin in public schools, both the Supreme Court and the lower courts have struck down anti-evolution statutes policies and disclaimers, as well as balanced treatment legislation?
Yes, and I think that I probably agree with a good number of those cases. And I think a good number of those cases were properly decided.
Would you agree with the principles set out in Edwards versus Aguilar, striking down a statute that forbid the teaching of evolution in public schools unless creation science was also taught?
Yes, I agree with that.
Would you agree with Epperson versus Arkansas, striking down a statute that made it unlawful for teachers to instruct on Darwinian theory of evolution in public schools?
Very definitely.
Would you agree with Freiler versus Danny Paga, and for the court reporter, that is Tangipahoa, Parish versus Board of Education, invalidating a disclaimer required to be read to students prior to teaching evolution because the disclaimer had the primary effect of endorsing a particular religious view?
I take exception to the Freiler case.
You take exception to the Supreme Court in that case?
I don't think the Supreme Court decided that case. I believe it was decided by the 11th Circuit, and the
Fifth Circuit.
Supreme Court simply didn't take cert.
And by the Supreme Court not taking cert, that means that in essence they stood by the ruling of the Fifth Circuit, correct?
That means that they couldn't get the votes necessary to accept it. That does not mean that does not endorse a lower court ruling.
Well, it certainly doesn't set it aside, does it?
No, it doesn't. I would agree with that.
Right. Daniels v. Waters, 515 Federal 2nd, a Sixth Circuit court, declaring unconstitutional a statute that required a disclaimer to accompany all theories of origin except the biblical theory of creation, and that precluded the teaching of occult or satanical beliefs of human origins. You have no problem with that case, do you?
Mr. Gonagary, I will have to say I have not read that. I can't recall reading that particular case, and
how about
I have 100 cases or more in my computer here, but I don't.
It is unfair to try to have you.
But I would.
Let me just finish this. Let me just finish this,
yeah,
sir.
Just
give me a second. It is unfair, Mr. Colbert, to have anyone standing there questioned about a long line of cases and to be asked specifics. So I'm going to reframe the question in this matter.
Sure.
Would you agree that the Establishment Clause of the United States Constitution requires neutrality in the teaching in our schools as far as faith?
Yes.
And your argument then would be that since neutrality is already breached by methodological naturalism, that it is only fair that intelligent design be permitted as an alternative theory?
No, I don't think so. I think that what methodological naturalism does is that it prohibits a particular point of view based on, even if there is scientific evidence that supports that view, methodological naturalism essentially rules it out of order. And I think that is not, and when you're in an area that impacts religion, origin science, then I think that any time you get into a discussion of religion and you decide we're going to skew the evidence one way or the other, I think you violate the idea of neutrality.
And it is your opinion, therefore, that evolution as it is being taught across this country today is skewed in a biased manner towards methodological naturalism?
I think so. I think that, and that's been my experience. I've been in a lot of different states, and I've seen a lot of, the last 5 years has just been, and so I can cite a number of different examples of the implementation of it, in addition to what we've heard today in testimony.
And you would further agree with me, would you not, that term is found nowhere in the Kansas standards?
Yeah, I don't find that specific expression in the Kansas standards.
And you would agree further with me, would you not, sir, that in order to bring this issue to bear, one would have to, in essence, read between the lines to assume that is the purpose of the standards, correct?
Well, see, that's the problem. If you're going to, and it is, see, it's admitted that it's used. And John Stavers admitted it, Steve Case has admitted it, the reviewers of the peer review all admit that methodological naturalism inheres in the Kansas science standards. And it is surprising to me that the admission says it's there, but you can't find the term. That really is, to me, very damning.
Isn't what they're talking about, sir, that as scientists are simply interested in finding natural answers to the world around us?
I think that's true, but when you get into an area of origin science, you have a different kind of science. It is much different than other kinds of science. It's historical. That requires competing multi-hypothesis. Naturalism essentially limits. When we use methodological naturalism, why do we even discuss or investigate origins? Because we know the answer before we've even started the investigation. What caused, where do we come from? A natural cause. I mean, why even discuss origins? You know in advance what the answer is.
Mr. Calvert, do you disagree with I think we're just going to be going back and forth, and we're simply not going to agree, sir. And I respectfully disagree with you, and we'll leave it at that.
Mr. Aganagari, I really want to thank you for your demeanor in these proceedings. I think that you've done a good job defending your client, and I just want to thank you for participating. I think it's given the public a much more interesting discussion.
Thank you, Mr. Calvert, and I look forward to the opportunity of presenting our side this coming Thursday.
Yes, sir.
Thank you, sir. By the way, I do have a little bit of time left, don't I? There's a line of questioning I forgot to ask you about. How much money are you?
I knew that was coming.
How much money are you expecting from the state of Kansas taxpayers for these hearings?
Well, my understanding is that our witnesses. I'm not expecting any, but our witnesses, other than myself, other than Dr. Harris, I don't think we have any significant expenses. But other witnesses are subject to a $5,000 expense budget.
And that $5,000 expense budget is being paid by Kansas taxpayers?
Yes. I believe so. I assume it is.
And the $5,000 is coming from the Board of Education's budget?
I assume that's the case, but I don't know.
And those are dollars that would normally go to further the education of Kansas children, correct?
I believe that's the function of this hearing, yes.
And included in the $5,000 expenses, for example, is the expenses for the travel of the gentleman from Turkey.
Not from Turkey. His travel, he was in the United States and on other business, and so his travel expenses simply from Washington D.C. to Kansas City.
And the expenses of others that have come here and testified.
Yes.
Does it include lodging for those individuals?
Yes.
Does it include their food?
No.
So you're not paying for food?
No.
Or not you, but the taxpayers are not paying for their food, but they're paying for their hotel.
They're paying for the hotel.
And do you think, sir, that the Kansas taxpayers, well, I know what your answer is going to be. Sir, he's that gentleman's out of order. That gentleman is out of order, and he should be removed if he continues.
That's out of order. We're not taking comments from the audience, but nope.
No comments.
Please.
Mr. Chairman, may I make one statement on behalf of my law firm? Would that be okay, Mr. Yagoro-Nagari?
I have no problem with you making a statement when I'm done. Excuse me, sir, when I'm done.
I'm sorry, I thought you were.
No, not yet. And the expenses that are being paid, how are those going to be paid? Are they going to come directly to the witness from the state of Kansas, or are they going to be funneled through you?
The witnesses have been asked to submit expense vouchers.
To whom?
They will be submitted. I will be sort of a conduit. I'll gather those expense vouchers, and then I will submit them to the state of Kansas, making sure that there are no expenses on there that we should not be asking the state of Kansas to pay for.
And you'll make that determination?
Well, I mean, the state can second guess me.
And it is true, is it not, that just before I got started on this process, the budget that you sought was $20,000 for yourself, correct?
No, that's not the case.
How did the figure of $20,000 come about when I became involved in this?
I think that the figure of $20,000, and you'd have to talk to the Department of Education, and this is secondhand knowledge, but my understanding was that the department and the state board were budgeting $20,000 for the entire process, not just for the witnesses on this side. And so that would include, it was contemplated that you would have a like number of witnesses, and so there would be expenses for them, and that there would be expenses for their court reporter, and so forth. My guess is that the expenses will be under the $20,000, but maybe not.
Well, sir, I'm not accepting a penny for any of the work we've done. I think that would be, in essence, stealing from the children of the state. Further, I think it is important to also place on the record that it was after my objections that the $20,000 budget was reduced to $5,000. Is that correct?
I just know that we were submitting a list of witnesses that looked like it could very well, it was essentially a list of witnesses without any cap on the amount of the expenses. And the State Department of Education said, we don't think it's appropriate to have an uncapped, or at least that was the impression I had, and that the expenses, you need to figure out a way to limit your expenses to $5,000. And to me, that was a reasonable request. And so that's what we've tried to do. We have found a lot of volunteers, for example, that are handling all the ground transportation. And by the way, I just can't thank those volunteers enough. They have done an absolutely Trojan job in getting witnesses back and forth between KCI and Topeka.
And who, sir, made the arrangements for the lodging and travel for these witnesses that testified on your side of the case?
The lodging was arranged by, there was the Department of Education contacted the Ramada Inn, I believe, and got a per room rate of like $50 a night or something like that. And the witnesses made their own arrangements for travel in terms of airfare and things like that. And so they are paying for those expenses up front. And they will also, they're paying for their hotel bills as they check out. So at this point in time, the state hasn't spent a penny on any travel expense.
Thank you. Nothing further.
Just to state for the record, neither I nor my law firm are getting one penny from this $5,000 fund or any other Kansas funds. This is entirely a pro bono effort of Arnold and Porter. Had Mr. Irigonagari presented witnesses next week, I would have been available to question them next week, and that would also have been at no cost to the people of Kansas.
Thank you, Mr. Calvert. None of us have any questions for you.
Okay. Thank you very much. I would like to say just a word of thanks to the court reporter, to Mr. Irigonagari, to the committee, and to the Department of Education. They have done an absolutely yeoman's job, just an absolutely terrific job in the logistics on this hearing, and they're to be commended for it, and thank you so much.
We will meet again next Thursday at 8:30 in this room. And thank you for your interest in Kansas education.
Audible hopes you have enjoyed this program.